Welcome to another episode of the Ambitious Legacy Podcast. I'm your host, Sabine the Purpose Lawyer. Thank you for listening and thank you for helping me to be on purpose. All right, what's up, real estate enthusiasts? I know you clicked on this video because it said real estate in the title. I know that's why you're here. Well, welcome back. If you've never been to this podcast, you should know that this is a place where we talk about protecting and preserving your stuff and show you how to put the generational into generational wealth. All right. So, we're going to talk today about real estate and how do you actually transfer and pass on real estate. A lot of people are confused about this, and this is the one area that I find ends up in court and ends up in family conflict issues because of the fact that people are confused about how you pass on real estate. So, how do you protect the real estate you have and make sure that you're giving it to the right person, or that your intentions for how you want this real estate to be received is actually followed? So let's talk about 3 ways on how you can actually transfer real estate and what it sort of means when you do it in these particular ways. All right. So first off, we're going to talk about what the common thing that people think is to write a will, right? So writing a will allow you to basically put instructions in this document that will inform a court or tell a court, right, how you want your, well, since we're talking about real estate, we'll keep it to that, how you want your real estate passed on if you were to pass away, right? So you write it up. You have to make sure that you follow the laws of the state that you're in and that your state laws are basically your state laws for will signings are followed, because it does matter. And so as long as you do those things, your will should be valid. And as long as your will is clear on exactly what you want and exactly what assets you're talking about, your will should be followed by the court. Now, there is a caveat to that. If people are fighting over your assets and if they are raising questions as to the validity of your will or your mental state when you sign the will, this could cause a problem and it could make this process of transfer be delayed for a long time. Right? But if that's not the case and all is well, your family member, your next of kin will have to take this will, or the executor that you name in the will, right, will have to take this will to the court, open up a case, and have the court give instructions on transferring this assets, or give the legal authority on how to transfer these assets, right? So a will is a way to do that. Now, you want to make sure that if things change in your life, that you update this will and you follow the same legal requirements that you did the first time to make sure that it's valid. You do that again, right? And then you also make sure that you say whether the prior wills or the old wills that you had, you want to make sure, are those still valid or are those canceled? Like, all that language has to sort of be in there. So that's way number one that you could transfer your real estate property, is through a will. Now, some of you might say, listen, if something happens to me, I want to make sure that my assets go to my loved ones. I do not want them to have to go through a court process. And I can understand that because we also, I'm an attorney at my firm. We deal with situations where people pass away without planning or with just a will, and then it has to go through this court process. It's annoying, it's tedious, it costs money, it takes time. However, for some people, it's okay, right? But if you're those who say, I don't want that, and I don't want my family to potentially be fighting, I don't want everyone who is related to me to be notified that this situation is happening. I just want those who are going to benefit from my estate to know what I left them, and that's it. So then you're the type of person who might want to consider a trust. So a trust is a way that you can leave your real estate assets. You can give directions to this, leave directions in this document and say, hey, something happens to me, I want this family member or these family members or this friend or cousin or whatever to receive the benefit of this real estate asset. And so if that is the case, if something were to happen to you, the person who you leave in charge, which would be called your successor trustee, that person will be able to say, okay, so-and-so passed away. Here are the instructions. I now have the right and authority to transfer this real estate to you, person who's benefiting, and or they can also keep that real estate in trust and continue to manage it, or hire a management company, let it continue to produce income, and have that income benefit the persons who are supposed to benefit from it. But the person who's creating it, you or someone you know, That's the person who gets to decide how the real estate is distributed, whether it's kept, whether it's sold, whether it's transferred to whomever you want to go to. You get to decide within the trust. The difference between the trust and a will is that there is no court process, right? There's no what we call probate. No probate. It's easy, it's fast, it's private. Nobody has to know except who's benefiting, right? So that's the difference. That's way number two, right? All right. The third way to transfer real estate, it might be right for some people, right? So it's how your real estate title is held. You may not need to have a will or a trust, right? If it's right for you, you can just transfer your real estate through the deed document, right? The title of the property is called the deed document. And that deed document, there are three different ways how you can deal with your ownership in real estate on the deed. So one way is if you hold it as tenants in common. If you have it, your title as tenants in common, like for instance, let's see, Joe and Donna as tenants in common title on the deed, right? So Joe and Donna would own the property. If one of them passed away, their share goes to their loved ones, not the other owner, right? So in that case, you have to have something like a will or a trust to then direct where your share goes, like to whom your share goes, right? So that's not a way to hold title. If you want it to go automatically to somebody, you have to have another document like a will or a trust to then direct where that share is going to go. Now, if Joe and Donna own this property jointly on their title, or joint tenants with right of survivorship on their title or deed, then if one of them passes away, it goes automatically to the other person. Nothing else has to happen. No court document, nothing further has to happen. It's automatic. It's called by operation of law, like that, right? So if that's okay with you and that's what you want to do, you can own title with somebody jointly and have it go automatic, and you don't have to worry about anything else, right? So now, same thing happens if you have a spouse. If you're married and you're both on the deed, then it's going to go automatically to the spouse. So if you are in a second marriage and you do not want your share or to go automatically to your spouse, where your children from your previous marriage or prior to this marriage will not get anything, then you want to make sure you change that deed. And you also want to make sure you have another planning document to further dictate or further confirm that that's not what you wanted to happen, right? So it's really important how title is held, because you can see how things can happen automatically without you expecting it to happen automatically. And I see that particular piece a lot. I see it a lot where people remarry, they have their spouse on their real estate asset, and it may not be the real estate asset that they bought during marriage. It could be something they had before, or that they acquired before, and then the children from the prior to this relationship are like, oh man, like we should have benefited from this. Now, that may not have been the person's intention. Maybe they did want this asset to go to their loved one. All of that is fine. It's just to make sure that you understand what's happening. So what did I say here? That was a mouthful. So for the third way that you pass on real estate, you can have your deed document actually state how you want it to go. If it says jointly, or if you're married to the person who you own the property with, it will go automatic, right? And that is the third way to pass on your real estate. So that was quick and dirty, right? So now you know the three ways that you can pass on real estate. I don't want to say this is the exclusive three ways across the country, but this is the main three ways that I know of off the top of my head, that you could pass on real estate. So if this was helpful to you, please definitely like this video and subscribe. But not only that, if you have information, if you need information around this, or you need help with estate planning, asset protection, you want to talk about passing on your real estate asset, please feel free, reach out to us, the Ambitious Legacy Firm. Our contact is in the show notes. And now, if we cannot help you, we'll be happy to tap you into our network so that you can get the help that you need wherever you are. All right. Another thing, I wrote a book called You're Richer Than You Think. You're Richer Than You Think talks about all these different topics of trusts and wills and real estate and business entities and everything that you need to know about this area from a novice standpoint. And so it will help get you the information that you need. And so that is only also linked in the show notes. So please feel free to pick up a copy. And thank you for being here. Don't forget to come back next week where I share all these different topics on asset protection and estate planning. And like I said, protecting and preserving your stuff, putting the generational into generational wealth. I will see you next time.